Greetings, dear colleagues, candidate and the public. Today, on January 15th, 2025, the advisory group of experts has gathered in full force and effect to interview the candidate for the position of the judge for the Constitutional Court of Ukraine, Oksana Klymenko. In particular, all 6 members of the AG are present: AG Secretary Maureen O'Connor, AG Member Hanna Sukhotska, AG Members Yaroslav Romaniuk, Ales Salar, and Vasil Shakun. Also present during the interview are deputy members of the AG, Thomas Griffith, Richard Barrett, and Vitaly Machinchuk. I would like to know that we are working in a shelter, so in case of an air raid, the interviews will continue without interruption. I would also like to remind you that the interview is being recorded and will be broadcast live on the AG's resources and the CCU website. Therefore, I would like to draw the attention of the AG members and the candidate to limit the use of sensitive data and restricted information during the live broadcast. If it is necessary to discuss such issues, the AG will limit the broadcast for this time. We are ready to begin. So I will now hand the floor over to AG Secretary Maureen O'Connor for a brief introduction of the candidate and a reminder of the interview process. Please, Maureen.
Good afternoon welcome, dear colleagues, and everyone who is watching this afternoon. As our chair of the AGE has already said, the advisory group of experts will now conduct an interview with the candidate, Oksana Klymenko. I'd like to remind you that the opportunity for an interview is a mandatory stage in the assessment of candidates as part of the evaluation of their compliance with the criterion of high moral qualities. Each interview will take approximately 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer the question clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement of up to 5 minutes. I would also like to note that while processing the materials on candidate Klymenko, the AGE sent her questions for written explanations, so the candidate had the opportunity to prepare and to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine, Oksana Klymenko, who was admitted to the competitive selection by both the Rada Committee and the Competition Commission under the President of Ukraine. Ms. Klymenko is a chief research consultant at the Legislative Development and Legal Policy sector of the Verkhovna Rada Research Service. From September 2003 to the present, the candidate has been working at the Verkhovna Rada Research Service. In the period of 2015 to 2022, the candidate worked part-time at the Institute of International Relations of Taras Shevchenko, National University of Kyiv, in particular as a member of the Specialized Academic Council, lecturer of the disciplines International Civil Procedure and Actual Problems of Civil Procedure. She's chairwoman of the Examination Commission of the Department of Private International Law. Ms. Klymenko also has a Doctor of Law degree. In 2012, she defended her dissertation on the relationship between public and private interest in the aspect of compulsory alienation of private property rights objects due to public necessity. The candidate is the author of more than 170 scientific publications, many of which are devoted to constitutional law. Ms. Klymenko, if you would like to add anything to your presentation, you may do so now and take 2 to 3 minutes to do so.
No, thank you, Mrs. Maureen. This is a great introduction. Thank you.
All right, colleagues, we will start the conversation with Ms. Klymenko. I'm going to ask you the first question. In your response to the written questions of the advisory group, you stated that from 2015 to 2020, you lived in an apartment in Kiev that belonged to your friends. Why did you not reflect the use of such real estate in your declaration? In accordance with Clause 2 of Part 1 of Article 46 of the law on prevention of corruption, the declaration shall contain information on real estate owned by the declarant and their family members on the basis of private ownership, including joint ownership or leased or otherwise used by them, regardless of the form of the transaction as a result of which such right was acquired. In view of the above, how can you explain whether your actions regarding the failure to declare the use of the real estate comply with current legislation on the prevention of corruption?
Thank you for your question. This question was part of the written communication provided by AGE, and yes, I do confirm that I did not include this information in the declaration, since this was an apartment of my friends who offered me to live there for some time free of charge. As for this apartment, we did not have any contract or agreement regarding the use or ownership according to the legislation. And the declaration shall contain information on the legal transaction as well as with written communication. So it was supposed to be some contract in a paper form, in a written form, in a simple written form. So just a contract between the person who provides the apartment and the person who uses the right to use this apartment. So these are the legal prerequisites that imply private ownership. And if I speak about this apartment and the opportunity to use this apartment, we did not sign any contract. And since this was just a friendly support during some period of time, I was not sure how long I would stay there, and I did not have any financial obligations in regards with the using this property, if we can say so, because this was provided by my friends. We never talked about this. I was only covering the utility bills within the period when I stayed there. I do hope that I managed to explain this.
Thank you for your answer. So, according to the law, you are correct. There has to be a transaction and some sort of understanding between the owner and the occupant. So, from your answer, I would surmise that the phrase, regardless of the form of the transaction as a result of which such right was acquired, you had no right to stay there. Would that be a fair statement? You don't believe that you had a right, an enforceable right?
Well, I did not have any legal grounds, and we cannot consider our interaction with the friends that I had the right to own this property, but we had a spoken agreement with my friends that we can consider this as some sort of ownership, but it was legal according to the legislation. So a spoken transaction is what we had, but obviously I did not have any legal rights for this property.
Thank you. Yourself?
Oksana Klymenko to was.
Oksana Mihailovna, I also have a question to you. You are a person who is, according to the law, should regularly declare your income as a civil servant. We did analyze these declarations and we discovered that in your e-declarations for 2015-2018, you declare the right to use a 73.8 square meter residential building in Kyiv region. It was a building and 2 land plots. This building and 2 land plots were purchased by your son in 2011. According to the contract, the cost of this building and the land plot was 72,000 hryvnias. Could you please elaborate on the source of income for such funds for your son? Were you involved in the purchase of the house? Yes, I was involved as the source uh, of income, as the source of funding the purchase for this residential house. Namely, I will start from the beginning. In August 2011, yes, please make sure to stick to the timing of your answer. So, in 2011, my son became an owner of a residential house and 2 land plots that are situated near this house. The source of income for this purchase were the money that our family, that consists of 3 family members, namely my husband, my son, and I, we sold our properties in Kyiv, namely 2 apartments. In one of those apartments, do you have a documentation that proves this? Yes, I provided the documentation for this. One apartment was purchased for my son. We had a mortgage on this apartment, and we fully repaid the mortgage. And obviously, I participated in repaying the mortgage, and 1/3 of the apartment, according to the contract of privatization for our joint apartment. So you sold the privatized apartment, and with the money that you received from selling this apartment, you purchased the residential house and the 2 land plots. And then you, no, then back then we sold both apartments, and with the money earned from selling 2 apartments in Kyiv, our son purchased the residential house and 2 land plots. Did you buy this did the son buy the residential house for himself? Yes, he became the owner of this property since we decided that his part in the general family property at that time, with the agreement of all of us, was the biggest. We decided to purchase, our son decided to purchase this residential house. Does he live there? He did live there before 2013, and then he went abroad for studies. He went abroad to get education, and since then he lives abroad. So since 2015, you have been registered in this residential house and you live there. No, I was registered in this house in 2013, and in July 2015 I moved out from this residential house due to some family reasons, and I came back there in 2020. I understand. Again, according to the land plot sale and purchase agreement, the active purchase was referred to two land plots, so approximately 45,000 US dollars. At the same time, in your declaration, you state the value of one land plot, 0.15 thousand hectare, with the price 72,000 hryvnias, and another land plot, 0.26 hectare, and also with the price 72,000 hryvnias. Why do you indicate in your declarations the value of the land plots and not the value that was actually paid and specified in the purchase agreement for such land plots? Thank you for the question. I did provide written explanation in our written communication. Allow me to elaborate on this. So I can assess this information as a technical case. The subject of the sale and purchase agreement was one and single object, which was two land plots. They are different according to their purpose, therefore they have different register numbers. So if this was a single land plot, it had a single register number. I understand this, but the question is, why did you purchase it for $45,000 and then you specify a completely different sum of money? The thing is, when I was filling out the declaration for each object of this property, I was supposed to specify the cost. Otherwise, the program does not allow you to submit the declaration. I even consulted with our specialist how I could specify this. So I either was supposed to specify the sum, the total sum, and or I had to declare two land plots. And the cost for these two land plots was not specified neither in sale and purchase agreement nor officially. Therefore, this is technical impossibility to provide this data in the declaration. Yes, this is basically a technical glitch. Technically, you cannot do this, and legally, it does not correspond to the data that they have. So, you provided the data based on the expert assessment. Why did you not show the cost that you actually paid? I believe that then the cost would be higher than the real cost, and it wouldn't make sense when I fill out the declaration and I can simply put the sum of sale and purchase agreement. I understand this, but if it just should meet the criteria of the legislation. Okay, then another question. Why did the expert value was why was the expert value so low? Doesn't it mean that the seller will pay taxes based on the sum of 70,000 hryvnias and not $45,000? And you encouraged this.
I didn't see it that way, but I definitely have nothing to do with the expert activity and who ordered this expert appraisal. Of course, the seller, because it's their duty to provide all of the documents, the set of documents confirming both from the legal point of view and the technical peculiarities of the property they are selling. The notary is checking these documents. And the buyer has nothing to do with the preparation of the documents, materials, including the evaluation or the technical assessment. Okay, so you agreed with the seller on the cost, and this is $45,000, and that is the amount that was paid to the seller. Do I understand you correctly? Yes. Okay, thank you.
Question regarding your money assets. In your e-declaration for 2015 to 2019, you did not declare any savings in Section 12. Section 12 is for monetary assets. However, in the electronic declaration of 2023, you declared monetary assets in the amount of 116,000 hryvnia in a bank, and in the form of euros, you had 1,800, that's 1,800 euros that are deposited in France. Why did you not declare the cash savings during 2015 to 2019?
I did not declare, indeed, in my declarations for 2015-2019, I did not declare any savings that I had by the end of the year, because in fact I didn't have it in the amount that would subject to declaring. So the funds that I did have, it did not exceed the set limit that was supposed to be declared. I would like to refer to the question of Yaroslav Mikhailovich here. In fact, that I was the subject authorized to declare this assets as of 2015 till 2018, because in 2018 the structure where I worked, the Institute of the Legislation of Verkhovna Rada of Ukraine, it was deprived of the status of the state service. So I didn't have the duty. I wasn't obliged. I was now subject of declaring anymore. I was not. I did not subject to fill out this declaration. But for some time, I mean, the situation seemed uncertain for us for some time, because I used to, back then, I had the position of the manager of the department, and I thought that my position was in line with the criteria of the person who is obliged. So I tried to find out, should I declare or should I not? But as far as I know, our management has authorized a certain person who had the official ties with the National Agency on Corruption Prevention, and we were informed that we're not obliged to declare anything, but I still did.
Не було цих коштів, да.
All right.
And I'm sorry, but you also spoke about the 2023. Why did I declare certain funds? Because in the period as of the 19th until 22nd, 2022, I had savings, but I did not subject to declaring it. And the savings that I had, in fact, I used as them for my living, and I transferred part of them into currency assets. I opened the bank account, which is the mandatory condition in France to be able to, for example, have the insurance, and that's very important. So that's why I opened that bank account, and I was using it.
And then, so you say you had no savings between 2015 and 2019. You were just living off your income at that point. But then from 2019 to 2022, you were able to save 116,000 hryvnia and the euros, the 1,800 euros. Is that statement true?
Це правильно?
Yes, it is true.
What was the source of the money that resulted in the savings accounts?
Це моя заробітна.
My salary. only my salary, part of which uh, tr- tr- I exchanged it for euro. In fact, I opened this account and I didn't even use those funds. I think I only had to buy some tickets, maybe. I wasn't really using it. I mean, I used more the funds that I had in my hryvnia account.
I understand. In accordance with Clause 8, Part 1, Article 46 of the Law of Ukraine, on, quote, on prevention of corruption, the declaration shall indicate monetary assets held by the declarant or his or her family members, the total value of which exceeds 50 subsistence minimum as of the last day of the reporting period. Monetary assets are funds placed in banks, accounts, regardless of the type of the account, etc. Taking into account the above, how can you explain whether your actions regarding non-declaration of cash savings comply with the current legislation? Okay, that question would presume that you did not report the 116,000 and the euros. Did you report that? Did you declare that?
Я вибачаюсь, можливо,
I beg your pardon. Maybe I didn't understand the question. Did I declare where? After 2018, April 2018, at the end of the 2018, I was not subject to declare funds.
You did it anyway, and so your response would be, I'm presuming that you did an electronic declaration for 2023, and that's where you declared
вас
all of
зрозуміла.
these savings. Is that accurate?
я
I declared for 2023 as the requirement for the position of the candidate. So I declared all the funds that I had. The last declaration that I have filled out, I think it was in 2019 about the purchase of the vehicle. And after that, since we were told that we are no subject to declaring, I did not declare my funds anymore. But it doesn't, I mean, but I still worked. I still was receiving my salary, my pay.
I understand. We want to move on because we are limited with time. I appreciate your answers. I'm going to turn it over now.
Оксана Михайлівна, теж питання.
Oksana Mikhailivna, my question is also concerning the property and the sources of gaining funds to purchase it. At the end of March 2019, you purchased the vehicle Opel, a 2012 Opel, for 140,000 hryvnias, or approximately 6,000 USD. The question is about the source of income for the purchase of this car. And this question raised due to your declaration per 2018, where you didn't specify any cash savings. And in accordance with this declaration, on your bank account, you had 54,000 hryvnias. During first 3 months of 2019, you made, on the average, 40,000 hryvnias a month. So math doesn't confirm that you had this money in order to purchase the car. But you did purchase it. So my question is, what is the source of income for the purchase of the car? Where did you get money from? I provided the explanation. And these explanations are true. The sources of income to purchase this car was my salary, because I had no other sources. And I never had any other sources. Yes. I got my salary. So on your bank account there was 54,000 hryvnias for the first 2 months. So 2 months before that, before purchase you had 80,000, but I had cash funds. So my logical question is why in your declaration for 2018 you didn't reflect it? Because it was obvious that the general amount of this funds was not exceeding the set limit for declaring. Otherwise, I would have done it for sure. I am very, very conscientious about this, and I am sure and convinced. I mean, I can't see in retrospective of that moment of my life, but I am convinced. Okay, so you had them, but you didn't reflect them because according to the law, it did not exceed the set limit that was supposed to be declared. Yes, yes, exactly. And in total, together with your savings on your bank account plus the salary, yes, yes, this were my money. It was not an expensive car. I see. Next question. In accordance with Part 2 of Article 52 of the Law on Prevention of Corruption, I'm sure you are aware of, so you were obliged 10 days after the purchase of the car, you were supposed to inform about the significant change in the property status of the declarant during 10 days. You did that, but you did that on the 12th day. Why? Does this speak about your negligence with the requirements of the law, or does it show your irresponsibility? Please explain the situation. Yes, I admit the fact that I entered these changes. These were the latest changes, actually, that I have declared without subjecting to declaring. That I did it later than I was supposed to. I knew about this timeline of 10 days, but I couldn't quite find out whether or not I should declare it. Nobody could actually explain this to me, so I decided maybe it took me a few days to find out. Yes, I actually so what is to clarify? The law says very distinctly if the cost of the purchase exceeds the amount of the 50 minimum salaries, then you were supposed to. Yes, well, that's one thing. But on the other hand, when I started entering the data, and I remember this very well, when I started entering data on this purchase into my electronic declaration, then it turned out that I had to enter personal data of the seller, and I did not have those. And frankly speaking, I didn't have the contact details with the seller, and I ran out of time to find his contact details and for me to actually contact him and for him to provide me the information needed for this declaration. This was the main reason. I see. That is why I lost this time. And frankly speaking, I thought that I will do this, but then I figured out that I didn't have sufficient information. I see. Next question. In submitted the declaration for 2019, you were supposed to mention that in March 2019 you made this transaction of the purchase of the car. Why didn't you do it? It's not possible. If I was supposed to do it, I would definitely do it. Yes, you were supposed to do it. I mean, I can't check this right now, but if I didn't do it, it wasn't intentional for sure. I did submit the declaration. Do I understand you right? This is not intentional, but also lack of integrity. I would disagree with you because I did declare this car, this vehicle. We just discussed this. You declared not the car, but you reported about the significant change in the property status, but submitting the declaration for 2019 in chapter transactions of the declarant for the reporting period, you were supposed to show it to specify this transaction, the date and the amount. Well, maybe I was unaware. Sorry. Okay, thank you. Thank you.
Focus of the questioning now. In your response to the first request of the advisory group, you stated that on April 13th, 2022, you received a temporary residence permit from the French Republic. You stated that you lived in France from March 6th, 2022 until January 27th, 2024. However, at the same time, you continue to have a working relationship with the Institute of Legislation of Ukraine. You indicated that you received financial assistance from France on the general grounds of the temporary protection regime for Ukrainians, which included the calculation of 6.80 euros per day for general expenses and 7.7 euro 40 pence per day for accommodation. Why did you not declare any income in your 2022 declaration? And why did you not file a declaration in 2022?
I did not declare this income because in accordance with the legislation of France, this is not recognized as income. And it's obvious that when the country is providing the assistance, they legally do not qualify this assistance as income. I have a document, I have the tax declaration, I did it all officially. It wasn't requested from me, but I do have all these documents and I came to pick them up just to have them in order to be able to confirm that such means of support are not income. In the sense of the law of France. So no grounds to see them as income in accordance with the national legislation while I was residing in France and I was the resident of France at that moment. So there is no such grounds. Microphone, please.
University in May, in connection with your enrollment at the university, where were you living at the time?
Уточніть, будь
Please clarify that.
Rephrase that or repeat that. My
Будь ласка.
microphone was not on. All right, you stated in your written response to the AGE that you moved to Le Mans University in May in connection with your enrollment at the university. The question is, where were you living at the time?
До травня
Before May 2022 or after May 2022?
Le Mans.
я
I moved to Le Mans and I lived in the apartment my son purchased a year before. He took a loan to buy it.
And he owned the property.
ні, я
No, I lived alone. Because my son lived in another town. He just provided this dwelling to me.
The question, did you use the French government's rental assistance? In other words, did you pay rent to your son?
ні.
You didn't?
No.
Okay.
Я не отримувала, тому що
I got the package of assistance for Ukrainians to pay for accommodation, so I didn't ask about it. I didn't use anything. Because I lived in the apartment of my son, I just paid for the utility bills. I did not pay rent to my son, even though this apartment, he took a loan to buy this apartment.
€7 40 pence per day for accommodations from the French government. Is that right? And you still got that even though you didn't have to pay rent?
Yes. This assistance, 6.80 pence euros, was included in the single financial aid package for Ukrainians in case if they do not use social accommodation. If France provides social accommodation, then this financial assistance is not provided.
Okay, thank you. Let me ask you a basic question here. Why did you move to France? And if you can keep your answer pretty concise.
I moved to France on March 3rd, 2022 because I was truly scared and frightened. The residential house that I lived in was close to a strategic object, and for me, the war started at 4 in the morning. Everything was burning, everything was on fire, everything was exploding, people were killed. And when the territory was not captured from the air,
Okay, let me just do it. I understand it was because of the war, because of your proximity to what was happening at the time. You moved to France to avoid that experience. Is that a fair statement?
Я виїхала.
I moved to France because I wanted to save my life,
All right, let's move on because we have other
І я не
questions.
знала, які будуть
and I did not know what the perspectives were, and the tanks were really close to our village. They stopped 20 to 15 kilometers from our village. And then in France, I met a lot of people who moved at the same time.
Okay, all right. We've got other questions. What was your main activity during 2023 when you were in France on your leave? It was unpaid, and which you received from the Institute of Legislation of Ukraine. What did you do in France?
In France, I studied. When I came to France, and within the first 2 weeks term that we initially decided to stay there for were prolonged, I decided to learn French. I did not have any hope to be enrolled in any university, but I did receive an offer to study in the Le Mans University, and my son was aware of this. So I agreed, and I continued to work remotely in 2022. We had the opportunity to work remotely, so I continued to work remotely, and then I went on vacation. I took time off, and once I received the offer to enroll in the University of Le Mans, I asked whether I could combine these two activities, and I was told that I could combine this for 90 days, and after that, I could go on the unpaid leave. I decided that since I was enrolled in the university, and for me it was a unique experience, I decided to accept this offer, and I decided to stay for this course. There were several semesters. That is why I was studying, and I was on an unpaid leave starting from 2022. Once I was enrolled for the second course, I started studying full time. This was stationary education. We were attending lectures Monday to Friday full time. This was a full time educational process.
On Le Mans University.
I did not choose it to be honest. This project was organized, so to say, by my son. He was a student there. He also had an apartment nearby, so until May I lived with him, and this was also his plan to create something for me to do to stay.
Um, So I'm presuming that you became proficient in French?
Yes, I received a B2 level diploma. Unfortunately, I do not practice French right now, but I do hope that I will get a chance to practice French again. I do hope it does help me a lot, even in the recent times during my scientific work. It does help me a lot in comparative studies to take a look in the context of French legislation, and my level of language does provide more opportunities for me.
Great, great, thank you.
Дякую.
Do any of the members have questions?
У мене є невелике питання.
I have a question. We somehow omitted the information regarding the property of your son. So he went abroad to get education. Then he purchased an apartment in Le Mans. And as I understood, based on your answers, he also has some other properties. You also lived with him in his apartment and he stayed somewhere else. What are the sources of this income of your son as a student? Thank you for the question. When my son went abroad in 2013, as a student, he didn't have any income. And he went on a university program. He was enrolled in the university based on his results. And this also was the reason for him to obtain the visa, the student visa. For this, he needed to show a certain level of French language proficiency. He was studying as an ordinary student. He was also receiving tuition from France, and eventually, after graduating the university, he started working there, since the internship program is integrated in the educational process in France. And when he was at his second grade of studies at the university, he was already employed in a big company. And after that, he switched jobs and he started working at another prestigious company with quite a good salary. He was able to move out of dorm, he was able to start renting the apartment for himself, and honestly speaking, my income would not be sufficient even to help him to rent anything there. As of today, he continues working at a big company and he earns a decent sum of money. He's able to afford an apartment. It isn't a big apartment that he owns in Le Mans, but he took a mortgage on this apartment and his income allows him to do this. I was not involved in this, but I'm very proud of my son. Understood? Thank you. Dear colleagues, if there are no further questions to Oksana Mikhailovna, you may make a short closing statement up to 5 minutes. Thank you. Thank you for the opportunity. I would like to say thank you. I would like to express gratitude to the experts, to your team, for the time and attention that you paid to my candidacy. I want to express gratitude for the unique experience that I have gained throughout this competition. It is unique for me, and I believe that this is my little win. I also want to thank you for your work, for the mission that you fulfill. I believe this is a very important process, a very important experience that forms the practice of appointing the positions of the highest level of judicial system. And it creates the opportunity for independent and open competition. It is a crucial experience for Ukraine. I also want to express gratitude to the Parliament, to the Verkhovna Rada of Ukraine, to those people with integrity and diligence who work so hard, who do not make any delays in crucial decisions, who respond to external and internal challenges that we face today. I believe that this is what creates the grounds for functioning of both the judicial system and the society amidst the war. This is the way that we protect our democratic wins, and I truly believe that this ensures our future. I believe that this protects our European choice. I believe that this is the way Ukraine survives. Thank you. And I also want to express gratitude to the armed forces of Ukraine, to everyone who devotes their life to the protection of our land, of our independence, and to existence of Ukraine. I also want to thank my relatives who are also on the front line, and I do pray that they will hear my words of gratitude.
Хочу
And I also want to say that I promise that I also will be devoted to the responsibilities of the position with all integrity, regardless of the results of the competition. Thank you. Glory to our heroes, glory to Ukraine. Oksana Mikhailovna, thank you. Dear colleagues and the public, I hereby declare the interview of the advisory group of experts with candidate Oksana Klymenko to be completed.